your affirmation. Under this section, in the affirmation entitled Format, please check the box for live broadcast. After you have completed and signed the affirmation, please make sure you email them to Barbara Silverstone, who's on our call today, to her email address at barbara@rocklandbar.org in order to obtain your CLE credit for the program and to provide feedback to our committee about the program and to assist us in planning future programs. In order to obtain credit today, Barbara will give you one code, will be announced during the course of the program. Please make certain you put that code that Barbara announces on your affirmation. If you don't put the code in the affirmation, you will not be able to obtain credit for the program. Anthony Nia, who has spoken to our association many times, is the managing member of Ania, Scanlon, and Sirignano LLP with offices in White Plains and Somers, New York. For over 35 years, he has devoted his practice to educating and protecting the rights of seniors, the disabled, and their families from the cost of long-term care and estate taxes. He concentrates his practice on elder law, asset protecting planning, special needs planning, Medicaid applications, guardianships and wills, trusts, and estates. He's the author of hundreds of published articles and a frequent lecturer to seniors, disabled, the attorneys, CPAs, and financial advisors with respect to planning options available to seniors. He's certified as an elder law attorney by the National Elder Law Foundation, as accredited by the American Bar Association, past chair of the Elder Law and Special Needs section of the New York State Bar Association, past president and founding member of the New York chapter of the National Academy of Elder Law Attorneys. His accolades go on and on. We have had him lecture before us. We appreciate his time and his energy, and also the wonderful job he has done in our past programs. And I know he'll do a great job today in educating us and informing us in this area of the law. Anthony, thank you very much for attending and presenting today. I'll leave it up to you to start the program.
Thank you, Alden, and thank you for the Rockland County Bar Association Continuing Legal Education Committee inviting me to speak today. It's always a pleasure to present for the Rockland County Bar. I've had so many good friends and colleagues over the years there, and hopefully everybody is doing well. And maybe we've put some of these brush fires in Rockland behind us, because it was getting kind of scary last week, even in Westchester. So hope everybody's well. So we're going to talk about utilizing a trust for your elder law and estate planning needs, what the pros and cons are, and obviously probate avoidance is a very big pro of doing a trust. So I'm going not to do this, in a very micro level, very, detailed oriented, of giving you all sections of the code, etc. I'm going to give you a basic general overview of what a trust is and the different types of trust that you can create and how you can utilize those trusts for the purposes of your clients, yourself, etc. So a trust is an agreement between the creator of the trust, the grantor, and or the persons or bank or entity that is going to act as the trustee of the trust. And that trustee is a fiduciary. They're responsible for the management of the trust assets and income. So what I like to show my clients is a coffee cup. And I say to them, the trust is like a coffee cup. Right now, the cup is empty. It's unfunded. There's nothing in the cup. The trust terms only pertain to the assets that are in the coffee cup. So if the coffee cup is empty, you've never transferred any assets to it, then the trust is in essence a nullity. It doesn't mean anything because there are no assets in the name of the trust. There are different types of trust. A trust can be revocable or irrevocable. A revocable trust is one that can be terminated, amended, modified. You can change the provisions of the trust. You can change who the trustees are. An irrevocable trust is generally one that cannot be amended or modified, but it may have certain powers that are reserved to the grantor. There could be certain things that the grantor can do vis-a-vis that irrevocable trust. It all depends on what the purpose of the trust is. For example, An irrevocable trust that's used for Medicaid planning, a Medicaid asset protection trust, can allow the grantor to reserve a limited power of appointment where they can change their mind as to who the ultimate beneficiaries can be. And it can also allow the grantor to be able to remove and replace the trustees of the trust and appoint alternate trustees. In New York, if you are drafting a revocable trust, it is okay to be both the grantor of the trust and the sole trustee, so long as there are alternate beneficiaries named. Okay, so in New York, sole grantor and sole trustee is okay, so long as there are alternate beneficiaries. When you're talking about utilizing a trust for elder law and estate planning needs, well, you could use an irrevocable Medicaid asset protection trust. That is perhaps the principal vehicle that's used for Medicaid planning. You could do a revocable trust, which has some Medicaid planning value, but not a lot. And then you could use either trust for tax planning. And whatever trust you use, whether irrevocable or revocable, vis-a-vis the assets that are owned by the trust, funded in the trust, when you die, those assets will pass pursuant to the terms of the trust, whether it be revocable or irrevocable, and outside of probate, which is a very big advantage. Not that there's generally problems with probate in Rockland and Westchester. The courts are both very efficient, good courts in both Rockland and Westchester County. The problem is the delays. There can be delays. There could be things that happen to an estate that has to go through probate. There could be a beneficiary that's under disability that requires a guardian ad litem be appointed for that beneficiary, which will slow down the probate process and also increase the cost of the probate process. Do I need to be rich to have a trust? No, a lot of clients will ask that question. And if you do this kind of work, you'll say, no, you don't have to be rich. There is no wealth prerequisite to doing a trust. There are many reasons to use a trust. For example, the avoidance of probate. Remember, probate only applies to assets that are in your name alone on date of death. So if you die and you have property that's in your name alone on date of death, and you have a will, in order for that property to go to your descendants and heirs, the will has to be admitted to probate. Now, no matter what happens, that process, the simplest probate process from beginning to end, takes 9 months to a year. There are filing fees for the probate. There are legal fees for the probate, and there generally are delays and expenses. So it's a much more expensive process than, for example, just administering a trust when somebody dies. When you have a revocable living trust and even a Medicaid trust, you can appoint successor trustees. Having a trust also allows you to kind of organize your assets because you're funding the trust with assets. So now you're moving the title of assets into the name of the trust. Again, whether it's revocable or irrevocable is really irrelevant, but because you have to title assets in the name of the trust. There are some assets that do not go into a trust. For example, your IRA. You generally do not transfer your IRA to either a revocable or irrevocable trust because you generally have named beneficiaries and alternate beneficiaries on the IRA so that the assets can pass to those beneficiaries outside of probate when you die. If you want to have a trust, it would be for purposes, for example, that the money is going to an individual that's under a disability, and you may have what's called a special needs trust. That would be a third-party special needs trust. And of course, you can always use the revocable trust or an irrevocable trust to do estate and gift tax planning. So vis-a-vis a revocable living trust, whatever estate tax planning you can do in a will, you can also do an irrevocable living trust. So if in a will, you would have credit shelter trust provisions and or disclaimer trust provisions, you can have those same provisions in in a revocable living trust that you create. Wealth transfer planning, if you want to utilize your estate tax exemption. A lot of our clients now, because of the potential change in the law on January 1st of 2026, when the estate tax exemption federally drops from 12,920,000 to approximately 6 million, a lot of our clients are now making outright gifts of assets to trust for their children and grandchildren. The other advantage of a revocable trust is the continuation of asset management in the event of a disability. So when you have a revocable trust and you are the grantor and you become incapacitated or disabled, the successor trustee steps into your shoes and now is able to manage those assets that are in the trust, right? All they would need to do is present to the financial institutions evidence of your incapacity, that you're no longer able to manage the trust because you had a heart attack, a stroke, you have dementia, whatever the case may be, and now they can continue to manage the assets in the trust under the terms that you've spelled out. And when you die, the individuals that you've named as the beneficiaries are still going to get the assets in the trust. So rather than running around with the power of attorney and going to banks and getting the power of attorney recognized, and I can't even begin to tell you, even though the new power of attorney law went into effect in June of 2021, banks are still giving people difficulties. There are a lot of the larger banks now will not recognize a power of attorney that has two co-agents on it, because they're taking the position, well, we're not going to supervise what each agent does. And that's ridiculous. That's not what the statute allows. The statute allows you to have co-agents on a power of attorney. And now they're trying to basically say, no, only one person can act at a time. Now, generally, that's resolved by the co-agents agreeing that one person will have signatory powers, or only one signature is needed on the account. But again, the banks shouldn't really be doing this. For many reasons, there are many good reasons to have multiple agents on a power of attorney. One of them is because it creates a system of checks and balances, especially if the power of attorney is very broad and has a lot of gifting powers in it. And then the bank trying to take away that power just doesn't make any sense to me. What are the cons of using a trust? Well, the cons are you have to retitle the assets, and that's one of the things that we work with the clients with. We tell them that we're going to retitle your real estate, but when it comes to your bank accounts that are going into the revocable trust or the irrevocable trust, you have to do that. We tell them specifically what language to use in opening up the trust account. We get for them the federal ID number that may be needed if it's an irrevocable trust. Generally, a revocable trust does not require a federal ID number if the grantor and the beneficiary are the same person. Irrevocable trust, there's some dispute about whether a federal ID number is required. We always recommend that the clients get a federal ID number when doing an irrevocable trust. And predominantly the trust that we used for clients is one where it's going to be an outright gift, or it's going to be a Medicaid asset protection trust. And I'm going to get into the details of that trust in a few seconds. So revocable trust and probate avoidance. Well, one of the big reasons that people do a revocable living trust is so that they have control over the assets in the trust that are titled in the name of the trust, and that when they die, there's no need to go to probate. And it allows for the quicker administration of the trust assets and the disposition of the trust assets to the beneficiaries. Another reason for doing the trust is that, once you have the trust prepared, you can make changes to the trust, and you can still control and receive the benefits from the assets held in the trust during your lifetime. And then on death, it specifies who's going to get the assets. And again, avoidance of probate is a big factor. Now, I'll give you an example of how a good revocable trust will work. I did a revocable trust for my client, and she had the house in the revocable trust, and she had $200,000 in the revocable trust. Upon her death, her two children, who were the co-trustees, basically deeded the house to each other as tenants in common, and they divided the money. And all of that was done within 60 days of their mother dying. So in essence, within 60 days of their mother passing, they were able to distribute the assets and distribute the real property and the liquid assets and terminate the trust. Well, in most cases, it could take 60 days or more just to get the will admitted to probate. Here, the entire estate administration was completely wrapped up and done within 60 days of death. An irrevocable Medicaid asset protection trust. What is it? Well, it is what's called an intentionally defective grantor trust. Why is it intentionally defective? It's intentionally defective because the grantor reserves a limited power of appointment in the trust. They reserve the power to change their mind about who the ultimate beneficiaries of the assets are going to be in the trust. And by reserving that power and other powers as well, such as a swap power, when they die, the assets in the trust will be includable in their taxable estate, and the beneficiaries of the assets will get a step up in the cost basis. And for income tax purposes, they will still be able to get the STAR exemption, the principal residence exclusion, $250,000 if single, $500,000 if married. They get all the tax advantages of owning the property in the trust and the assets in the trust. The income generated by the assets is still taxable to them at their personal tax rate. So this trust, in essence, is what is known as a see-through trust. So for all intents and purposes, the grantor of the trust, right, is the person that's responsible for the taxes that on the income that the trust generates. If the assets in the trust are going to be sold, and the asset is going to be sold as the house, their primary residence, they're still able to utilize the personal residence exclusion. $250 if single, $250 if married, $500 if married. So it's a very valuable tool. The other advantage of this trust vis-a-vis a revocable living trust is that when you put assets into an irrevocable Medicaid asset protection trust, you are starting the 5-year look back, right? The look back period for gifts for purposes of nursing home Medicaid is 5 years. So a transfer of an asset, whether it be the house or non-IRA assets, into an irrevocable Medicaid asset protection trust is going to create a 5-year look back for nursing home Medicaid. Right now in New York, there is no look back period for Medicaid home care. However, as of March 31st, 2024, right, there is going to be a 30-month look back period for home care Medicaid, retroactive to October 1st of 2020. So this goes back to COVID. The law was passed in October of 2020, creating a 30-month look back period for home care Medicaid. But because of COVID, the implementation of the law has been postponed a number of times. And now we are being told by the Department of Social Services that the new period of ineligibility is going to start on March 31st of 2024, 30 months for transfers after October 1 of 2022. So what is the detriments of using a Medicaid asset protection trust? A, when you transfer assets to it, you can't use the annual exclusion. The $17,000 per person is not available. It is an incomplete gift, but you're not using your exclusion because you're not making a gift where the beneficiary has the power of withdrawal. If the limited power of appointment is retained, the gift to the trust is incomplete, which is okay, because if you want it to be an incomplete gift, then when you die, the assets in the trust are going to be includable in the grantor's taxable estate, and then the beneficiaries of the trust are going to get what's called a step up in the cost basis. Their cost basis in the assets they're inheriting from the trust when the grantors die is the value of the assets, fair market value on date of death. It's not the value of the asset when they put it into the trust or when they purchased it. It's fair market value on date of death. So unless their estate's going to be more than the New York exemption, 6,580,000, or possibly after 2026, the federal exemption, it's going to be probably very close to the 6,580,000, there's not going to be an estate tax. This kind of trust, the planning to utilize it really needs to be done early because of the look back periods, right? 5 years for nursing home Medicaid and 2.5 years, 30 months for home care Medicaid. So you don't really want to do a Medicaid asset protection trust when you're in poor health, because you're going to be disqualifying yourself for nursing home Medicaid for 5 years. You want to do it when you're in relatively good health and you do not believe you're going to be needing long-term care for the next 5 years. Okay? What other trust can we, how else can we use an irrevocable trust? Well, you could use an irrevocable trust that is a completed gift. So let's say parents and grandparents want to create a trust for their children and grandchildren so that they can create a trust where, let's say, one of the spouses is the grantor and either the other spouse or the parent of a grandchild can be the trustee. These trusts can be used for children, grandchildren, and the assets that you fund the trust with can be used for the health, education, maintenance, and support of the beneficiary, either for their life or until they've reached a certain age. Or if you wanted to, you could pick the occurrence of a specific event. You could say the assets in the trust stay in trust until my son has married and he's obtained a degree from a 4-year college. But if you want to, you can say the trustees can use the income and or principal for the health, education, maintenance, and support of the beneficiary. The payment of income can be either discretionary or mandatory, right? You can also set it up in such a way that the distribution of the principal is not made all at once. For example, you can say that a third of the principal is going to be distributed to the beneficiary when they've attained the age of 40. Half of the balance of the principal at 45, and then the balance of the principal at 50. Generally, this kind of trust is irrevocable. Generally, the grantor is not a trustee, but there is no prohibition that a husband and wife, one can be the grantor and the other can be the trustee. You're going to have to get a separate federal ID number, and you're going to have trust returns. And if it's a completed gift, right, there's going to be an amount. If it's a child involved, a minor, that's, that they're allowed to have of income. I believe it's $12,000, where it's taxed at a lower rate. But once you go above that $12,000 of income, and again, my number may be incorrect, when you go above that number of income, then it's taxed at the trust rate. So that's a con, as I'd like to say, something that's not positive, that the income generated could be taxed at the trust rate. But it depends if you want to invest in income producing assets or non-income producing. So generally, if you're going to have an asset for a grandchild, you may want growth assets to be part of the portfolio or be a significant part of the portfolio. And if they are growth assets, then generally you'll have very little income. What other trust can you do that can be actually irrevocable or revocable? You could do a third-party special needs trust. So a third-party special needs trust is a trust created by a third party for somebody that is a disabled person, a person who needs, for example, SSI, Medicaid, or other federal and state public benefits. Either they're going to be receiving them or receiving them. If it's a third-party trust, SNT, that means the assets used to fund the trust come from a third party, not the individual who is disabled. A self-settled SNT is created with the assets of the disabled person, and a self-settled SNT must contain a Medicaid payback. So, for example, if there's a lawsuit and the disabled person is getting a recovery from a negligence action or a medical malpractice action, that individual, those funds would go into a self-settled SNT, special needs trust, and that trust would require that on the death of the beneficiary, if Medicaid has a claim for reimbursement, that Medicaid be reimbursed first for the monies they've expended on behalf of that individual. Okay? Remember, special needs trusts are not generally used for day-to-day living expenses, but for special and supplemental needs. It can be used for food, clothing, etc., but there is a specific way in terms of utilizing the assets in the trust. You don't pay the assets in the trust directly to the beneficiary, okay? And once you've created the special needs trust, that beneficiary is allowed to still access Medicaid, SSI, SSD, or any other federal and or state public benefits without the trust impacting their eligibility. Another type of irrevocable trust, it's actually one that we use pretty often in our practice. So clients will come into us and say, I have life insurance policies, and they could have 2, 3 policies that are going to continue either for their life or for the next 25 or 30 years. And they don't realize that those policies are taxable and includable in their estate. So what we can do is, if there's an existing policy, we can create a life insurance trust. It's an irrevocable trust where the person that's the owner of the policy would be the grantor of the trust, and then the trustee would probably be the spouse and the children. And then what we do is we have them transfer the ownership of the policy to the life insurance trust, and we have the beneficiary of the life insurance policy be the trust. So, for example, if it's a policy that I own, I would continue being the insured, but I would no longer be the owner of the policy, and the beneficiary of the policy would be the trust. When you create a life insurance trust and there is already a policy in existence, right, there is what they call a 3-year clawback period. So in other words, when you transfer the policy into the trust, for that policy to be excludable from your taxable estate when you die, 3 years have to pass so that the clawback period does not take effect. So it's very important that if you're going to do this, that you do this as you're younger, not as you're older, right? So when you die and you have the life insurance trust, you can set it up any way you want in terms of who the beneficiaries are going to be. So a lot of times where we have a spouse, right, because life insurance is taxable, in a life insurance trust that we do for either the husband or wife, it says, when I die, the assets in the trust remain in trust for my spouse during their lifetime, either income mandatory or income discretionary, and principal also at the discretion of the trustees. However, as to invasion of principal, you can never have the spouse, if they're a trustee, to be involved in the decision. It's only the non-spouse trustees that can invade the principal of the trust, okay? And then you can structure it once that spouse dies to go to the kids, whether it's at a certain age, for life, etc. So by doing this and having this life insurance trust, now a life insurance policy that would otherwise have been taxable in the estate of the decedent will not be taxable if they transferred it to the policy and 3 years have passed. That's for an existing policy. But if they own the policy and purchase it at the same time that they do the trust, then they don't need to wait the 3 years. Okay? Probate. Well, probate is the process that takes place when you die and you have a last will and testament and you pass away with assets titled in your name alone. So a lot of people think that if they have a will, that a will automatically controls all their assets. Most people don't understand that a will only controls assets in your name alone, and that your will is not valid unless it's been accepted to probate. And accepted to probate means that it's been proved, that the court finds the will to have been validly executed, signed, dated. No one's filed any objections to the and contested the will. And if they did, those objections were found to be without merit. All right. And then once the will is admitted to probate, the court will issue letters testamentary to the executor. And if there is a trustee appointed under the terms of the will, you can also ask for letters of trustee. If you die without a will, but you have assets in your name alone, then an administration proceeding has to be commenced. And the administration proceeding is similar, right? But there is major differences. Major differences that in administration, you cannot dictate who is going to receive your assets. The assets pass pursuant to the laws of intestacy, depending on who is surviving you. And also you do not have the ability to select somebody who is going to be the administrator of your estate. In essence, almost anybody can apply to be the administrator of your estate. As I mentioned earlier, probate is time consuming. It could take anywhere from 9 months to a year. During the probate process, there are filings that need to be made, such as the inventory of assets, an affidavit of completion, which must be made after a specific period of time. The fiduciary affidavit of completion typically cannot be filed until 7 months have passed from the time letters have issued. And it often takes longer than 7 months to marshal the estate assets, pay the debts, file any tax returns, and distribute all funds to beneficiaries, right? So generally, if you were to take assets and distribute them before the 7-month period were to elapse, what would happen? Well, if a creditor showed up within that period of time and you had already distributed the assets, you would, as the fiduciary, could be held responsible to get back the assets that you distributed, depending on the size of the claim of the creditor. So you'd never really want to make distributions of assets unless the 7 months have elapsed. And to be honest with you, I'm not a big fan of making partial distributions of assets, because I really don't know if when we go to file tax returns, the estate tax returns, fiduciary returns, if properties are being sold, if there's issues with the basis, there's issues with capital improvements, et cetera. So I like to really wait until the estate has been fully administered. We filed the estate tax returns, if there's any due, paid the taxes, and let always some money aside, left some money in the estate to pay for any things that pops up in the event there is an audit of the estate, et cetera. So you got to be very careful when it comes to making a distribution of assets from a probate estate. The other things that are not good, the negatives of probate, it's public. Anybody can go to the court and look at your probate petition and see what assets existed at the time of your death. They can read your will. The probate petition requires a disclosure of the nature and value of one's assets, along with contact information for the named beneficiaries and the names and addresses of distributees, the persons who would inherit if there was no last will. Also, If you're a public figure and your will is going to be challenged, it's there. It's all out in the public. There's a lack of privacy. And again, this lack of privacy doesn't exist if you do a revocable living trust. Also, when you have to go through the probate process, you increase the risk of a will contest, right? Whenever a probate petition is filed, all distributees, all heirs at law under EPTL 4-1.1 must be cited, serve the citation, or execute a waiver and consent. And the citation basically says to them, you know, they get a citation with a copy of the will, and it says, come to court on such and such a day and show cause why this will should not be admitted to probate. Well, if you have a disgruntled child, a child that's been alienated from the decedent, you know, you may have that child come to court and ask to conduct the depositions of the attesting witness and the attorney draftsperson. And again, that's going to be an additional expense, et cetera, a delay in time, or the probate can go easily where everybody signs a waiver and consent, but you just don't know. There's always that risk of there being a problem when somebody dies and the will has to go to probate. And the grounds to challenge a will are lack of testamentary capacity, undue influence, fraud, duress. And again, you know, when you have a revocable living trust, right, you don't really have that risk. It's very difficult to undo a revocable trust. The person that is going to be challenging the trust first has to go to court and seek to be appointed the administrator of the trust with will annex possibly to conduct what's called a turnover proceeding, to argue that the assets in the trust really belong in the estate of the decedent. It's much more complicated to challenge a trust than it is to challenge a will. And again, a will contest can occur for a variety of reasons. A child, a distributee, is not provided for in the will. An unequal distribution of assets has been made in the will. And there's a question about undue influence, fraud, or lack of testamentary capacity. You know, a lot of clients wait until their late 80s and 90s to do a will. And when you have a will contest, it's very expensive. It destroys families. It can go on for years. And I like to say is that generally the participants, the parties, they're really not the ones that benefit from it because they're now whacking up an estate that's been depleted because of the legal fees of the attorneys involved. You know, it's a full-blown trial with depositions, discovery, et cetera. It's a very expensive process to go through a will contest.
Anthony, I'm going to interrupt you for a minute and give the code. The code for today's CLE program is ELDER, E-L-D-E-R. ELDER, E-L-D-E-R. Please write it down, and so you can write it in your affirmation later after the session. Thank you.
So if a client—
Anthony, can I just interrupt you 1 second? Just want to remind people that if you have a question for Anthony, please put it in your chat feature so that Anthony can go through the questions at the end of the program. Thank you.
Thank you. So if your client doesn't have a will and the estate goes through the administration process, well, then there's no issue of whether or not the decedent was competent or was free of undue influence or fraud, because of the laws of intestacy spell out who's going to get the money. So if you're survived by your spouse and children, the spouse will get the first $50,000 plus 50%, and the children will share the other $50,000. And again, using a revocable trust voids the probate. It allows you to do the estate planning, it allows you to do estate tax planning, and you know, you basically can avoid all the problems and dilemmas that are created by going through the probate process. So you'll probably be surprised to hear this, but a lot of our clients, when they come in to do elder law planning, they do both a Medicaid asset protection trust and a revocable living trust. They do both revocable and an irrevocable trust. They use the Medicaid Asset Protection Trust for the assets they want to protect and for Medicaid purposes. And then they use the revocable trust for the assets they want to control. And if they normally have an IRA or 401k, then when they die, no probate with the revocable trust, no probate with the Medicaid trust, and no probate with the IRA. So it's a win-win solution for them. Now you're probably saying, well, you can have a joint account and that will pass by operation of law and avoid probate as well. But the risk with the joint account is I die and I have a joint account with my spouse, and before my spouse dies, they never do anything to change the title on the account. So when they die, that account is still in their name, because when I died, it passed by operation of law to them, but when they died, the account was still in their name. So this is my contact information if you have any questions. If you go to my website, there are tons of articles that we've written over the years on various estate planning and elder law issues. Let me take a look at the chat box and see what the questions are. All right, let's do it the first one I'm reading here. A mapped trust requires distribution of income. Is the income considered an available asset for Medicaid application? So when you're doing the MAP trust, the Medicaid Asset Protection Trust, you don't have to say that income can be distributed to the beneficiaries. In fact, we try to recommend to clients not to make the income available to the individual, but it's not an available asset. So if you're getting income from the Medicaid Asset Protection Trust because it's mandated, then that income is counted as part of your income for purposes of Medicaid eligibility. If you're getting Medicaid home care, there is a way of protecting your income and utilizing it for purposes of paying your bills. And that would be by enrolling in a community pool trust. So if you have a community pool trust, then that income that you have above the amounts that are provided for by Medicaid can be used to pay your bills. But it's not, income is never considered a resource, it's considered available income. Same with an IRA, right? Same with Social Security and pension. The only income that's not counted for Medicaid eligibility purposes is Holocaust reparations and Crime Victims Compensation Board income. Those are the only two that are not they're not counted. Let's see the next question. What impact does long-term care insurance have on the desirability of a Medicaid Asset Protection Trust? Well, again, it's Medicaid, not Medicare. You know, actually, the long-term care insurance, in my opinion, gives you another reason to create the Medicaid Asset Protection Trust. If you've gone out and bought long-term care insurance, so now you have insurance in the event that you need to go into a nursing home or you need home care, you can leverage the value of that insurance by creating a Medicaid Asset Protection Trust, right? Because the insurance, right, will kick in if at a certain point in time when you're no longer able to perform 2 out of 5 activities of daily living. So the insurance kicks in, but if you've given away assets before you needed that, then those assets are also protected because the insurance does have limits to it. Unless you're using a New York State certified policy that allows you to basically get Medicaid irrespective of the amount of resources you have once you've exhausted all the benefits under the state certified policy. But remember, even with a state certified policy, they continue to look at all of your income. Can you walk us through what happens after the grantor dies and the process of passing the assets? Are there documents, acknowledgements that need to be signed in the process? Well, again, we're talking about an irrevocable or revocable trust. So the trustees will now step into the shoes. Let's say if it was a revocable trust and I was the creator and the sole trustee of the revocable trust, and I named my two kids as co-trustees, they basically step into my shoes and they manage the assets in the trust. They would marshal all the trust assets, pay whatever bills that are appropriate to be paid from the trust, and now they would begin the process of making distributions. Those distributions would be made in accordance with the terms of the trust. If there's an ongoing trust for a child or grandchild, that trust would continue. But if the distributions are going to be made outright, they would do that. But they probably will not make distributions to beneficiaries unless they've given the beneficiary an informal accounting, right? You always want to account to the beneficiaries for what happened in the trust. And then you want them to sign a receipt, release, and refunding agreement stating that the assets that you've received from the trust is all that you're entitled to, and that you're waiving any claims that you have against the trustees. So yes, you would basically administer the trust in the same way that you would with an estate at the very end. You would give an informal accounting to the beneficiaries unless they demand a formal accounting. If it's a trust, you wouldn't have them open an account, a bank account. Remember, the trust is the account, right? And an estate, yes. In an estate, you have to open an estate account. And that you can do once you've gotten letters testamentary. But with a trust, the assets are already in the trust, right? So the trust should have trust accounts. What would change is who the trustee of the trust account is. So if I was the sole trustee and now my kids are the alternate trustees, they would be the individuals signing on the account. They would give a death certificate to the bank, and now they would step into the position of the fiduciary as a trustee. With an estate, once you get letters testamentary and you're appointed the executor of the estate, or if it's an administration of the estate, then you marshal the assets into estate bank accounts. Okay? Any other questions?
Does anybody
Well-
have any questions that put in the chat, or you have a question on, do you draft a pour over will together with the trust? That just
Absolutely. If we're doing a revocable living trust, we always do a pour over will, right? We do it. And, you know, if the clients take our advice and they do the revocable trust and they have all their non-IRA assets in the revocable trust, and their IRAs have named beneficiaries and alternate beneficiaries, then when they die, there'd be no need to probate that will, right? There'd be no assets in their name alone that would require the will to be probated. And if the will does have to be probated, the will says everything to the revocable living trust. And the will also says, if the revocable trust no longer exists, then give my assets as follows. So we kind of basically repeat the terms of the revocable trust in the pour over will. We don't just say, give everything to my trust. We say, give everything for my trust. However, if my trust is not in existence and or has been terminated or revoked, then in that event, give the assets in my probate estate as follows.
do you still have to probate a pour over will?
You still have to probate
You have to probate the pour over will.
only if the decedent died with assets in their name alone,
Okay.
right? That's the only time you would probate the pour over will, is if the decedent passed and they had assets in their name alone on date of death.
Okay. We have another question. If you want to read it in the
If
chat.
assets from a trust are in different institutions, so it's up to the trustees to then take the money from the different institution and send it to the beneficiaries? Well, no. Generally what happens is they basically go into the trust, they pay the bills, and if the assets in the trust are stocks and the beneficiaries do not want to take the stock in kind, then they would liquidate the stock as soon as possible after the death of the trustee. I mean, as a trustee, while the trust is being administered, you don't necessarily want to keep all the assets in stocks because stocks are volatile. So, they would liquidate the assets as soon as possible. Thank you
Okay.
very much.
Thank you, Anthony, for everything. I appreciate the program and all that you give to the program and preparing these wonderful slides, and your presentation was excellent, and we look forward to your program in May. Thank you again for all your
Thank
time.
you. Stay well.
All right,
Thank
stay
you.
well. Bye-bye.
Thank you. Bye-bye.
Thank you, everyone, for attending. Good seeing everyone, and hope to see you at the program in May. Anthony will be back on, as I indicated, May 2nd, planning considerations for New York's new eligibility requirements. And don't forget to put in your code in the affirmation and email it to Barbara. And good seeing everybody. Stay well.
Good help.